honor of requesting Honorable Justice Krishna Dikshit to deliver the memorial lecture on law and dharma. Justice Krishna Dikshit, if I may say so, it's most ably suited to speak on the fusion of the twin concept of law and dharma. Justice Krishna Dikshit, please.
His Excellency, the Governor of Andhra Pradesh, Justice Abdul Nazir Saab, my beloved Chief Justice, Justice Anjaria Saab, Mr. D.L.N. Rao, ever smiling and ever generating humor also, my brethren, my friends at the bar, my colleagues, and ladies and gentlemen. The famous author Dale Carnegie, whom very often I quote because I take refuge under his second book, which he did not write, but he intended. His first book was How to Win Friends and Influence People. Many presidents, bureaucrats, officers, lawyers, judges used to read it. During my student days, my professor had presented one, thinking that I would read it and make benefit, which I did not. When he was asked as to which is his second book, he said, How to Antagonize Friends and Distance People. And his student asked how that book would be. He said, giving a long lecture, especially in the evening of the beginning of the week, is the surest way to become most unpopular. Therefore, I try to make my speech the shortest. That being said, the subject law and dharma. My professor Ajappa, the principal of University Law College at Dharwad, once told me that there is 5,000 pages literature on as to what is law. It starts from the days of Aristotle to the days of Wolfgang Friedman, the law in a changing society. Up to that, he used to quote John Austin, then Kelsonian pure theory of law, and then Holmes' gunman's theory. Like this, he went on. Then we asked him, at least tell us what are the sources of law. Generally, sources of law, which Salmond says, and Julius Stone agrees, Paton also, the first primary source of law is legislation. The second one is precedent. The best book you know, Precedent in English Law by Rupert Cross. There is a counterpart of Indian counterpart, Professor Lakshmikant's Precedent in Indian Law. Then the custom. Custom is law which is evolved by the society itself, whereas the legislation comes from the king or the conventional legislative bodies, which may include the delegates also. With this, we go to the private law, the law as between the parties, which we call as contract, pacta sunt servanda being its basis. Then opinio juris is the weak source of law, which the introduction to international law by Oppenheim treats, and there is another author, Broglie, they also treat it. Every day we have been operating with the law and instruments of law, and if you ask us what really the definition of law, it is like asking us what is the definition of time. We may not know the definition of time, but every day we operate with time. This is what Aristotle used to say. I know what is meant by time, but if somebody asks me to define, I cannot. Perhaps that would be my answer. Now, if I go on saying about law, I am a student standing in front of all the teachers, my teachers. Therefore, I do not want to cut a sorry figure by delving deep into this aspect of the matter. With this short background, how religion, dharma operate with legislative bodies, adjudicatory bodies, people, individuals, society, throughout history, what they did. That would be I will make an honest endeavor to give a thumbnail sketch of all this. It was Karl Marx who said, religion is opium of masses. And angels agreed with that. It is opium. There is one aspect which Bertrand Russell had treated. With your kind permission, I will quote it. Religion is primarily based on fear, fear of the mysterious, fear of defeat, fear of death. Fear is the parent of cruelty, and therefore it is no wonder if cruelty and religion have gone hand in hand. What is happening all over the world today vouches what he said today. Religion has too much emotive content all over the globe and throughout the human history. Most advanced jurisdictions also are not an exception to this. Religion shapes law. In all countries, Quran, Hadith shaped Islamic law. Bible, biblical literature shaped European, American, Australian law, parts of African law. Vedas, Upanishads, Bhagavad Gita, Mahabharata, Ramayana, scriptures have shaped much of Hindu law. Howsoever advanced a man may be, he cannot escape the impact of religion, says C.K. Allen, a famous author of 3 books. One is Law and Order, another is Law in the Making, yet another is Aspects of Punishment. He vouches it. One example, let us go to so-called most advanced jurisdiction, United States. In 1925, Butler's Act was made in the state of Tennessee. Butler's Act prohibited teaching of Darwinism because Darwinism run counter to tenets of biblical principles, tenets. And that was challenged before the district court. Then matter went to the Supreme Court of Tennessee, state of Tennessee. And one who argued was Clarence Darrow, the great lawyer. Perhaps you might have seen his biography by Irving Stone, one of the best lawyers of those days. And the Supreme Court of Tennessee upheld the validity of the legislation. Judges, after coming out, after pronouncing the judgment, is to say, Darwin's origin of species is very, very impressive. Perhaps that will figure out what the future of world would be. But this is in the most advanced jurisdiction like America. That's why C.K. Allen made that statement. In 1967, that act came to be repealed. Till 1967, that was the law. Then there are many cases where a person who was appointed as a postman, and on Sunday, the postal department asked him to deliver the mail. He went to court and to challenge that Sunday, according to Bible, is the prayer day and the day for rest. The state Supreme Court upheld the contention. Matter went to Supreme Court, Federal Supreme Court, and settled there in favor of the citizen. Whether it is legislature or the adjudicatory bodies or the society, escaping the influence and impact of religion is not an easy thing. In Australia, in Germany, in England, in these 3 countries, the distribution of Bible, even in public schools, is held to be lawful, subject to certain regulations. But displaying 10 commandments in the courtroom, the US Supreme Court said is not permissible, because the Supreme Court reasoned we have built China wall between religion and the state, church and the government, the separation, the true separation they wanted. The experience of people, the sensible people throughout the world, throughout the history, is that they are sufferers at the hands of the clergy. That is the reason throughout there has been revolution, and the people generally outthrow the religious zealots. It's a question of time. Howsoever strong the zealots may be, they will be thrown out. When we come to India, because Australia we have seen, even in Germany that is the case, in France there are such cases. In France, fixing the crucifixture in the public schools was held to be lawful. However, in the later decisions that has been diluted, subject to too many conditions. Let us come to India. We will not go to other border countries where turmoil is making the Shivatandava Nritya, whatever it be. In India, Dr. Ambedkar tried to revolutionize personal laws in 1950s. He was the law minister. He could bring about lot of change in Hindu law. The Hindu code came to be enacted, but he could not succeed in convincing a small section of Muslims who did not agree for improvements, developments in the Islamic law, and therefore it remained that way. Dr. Ambedkar lamented, and his wife Savita ji, in My Days with Ambedkar, specifically mentions about this. He could not do that one. How Indian jurisdiction has responded to religions. Let us go to Shah Banu, 1985 judgment. He quoted Quran, he quoted Hadith, and he said, Section 125 of CRPC, which obligates the husband to look after inter alia the wife and children, is applicable to minority communities, regardless of religion, faith, sect, etc. There was a big turmoil. There was a big turmoil. The turmoil was to that extent that Parliament passed a legislation. This happened during Rajiv Gandhi regime. And you have seen what Justice Krishna Iyer letter, which was addressed to Rajiv Gandhi. It's available in public domain. The rights of Muslim women on divorce, protection of rights of Muslim women on divorce act came to be enacted. Of course, that act has been interpreted by judges, and to a great extent, its vigor has been lost. Sayyid Bukhari, the leader of Muslims in Delhi, said, an oil merchant and a meat seller have interpreted our Quran, therefore we will not respect. He was hauled up for contempt, and Supreme Court said he was highly unreasonable. That was the response of Supreme Court when he commented on Shah Banu. Then Shaira Banu, you have seen, triple talaq came to be invalidated by the Constitution bench of the Apex Court. It was very overwhelmingly welcomed. Again, a section tried to play mischief, but that did not yield much result. Then, when we come to the other community, the major community, so-called dominant community, when William Bentinck passed a legislation in the council prohibiting sati, the people tried to stone him. They burnt his effigies. This was during the British Raj. And during British Raj, people were fanatic, regardless of the religions, all right. what happened to Roop Kanwar case. Roop Kanwar, an 18-year-old Hindu girl, was put on Sahagamana when the husband died, and an enactment was made saying sati system should be proscribed. There was such a big galata. You have seen those days in 1980s, 85 onwards, when Roop Kanwar was burnt alive. The people still agitated that such a legislation should not be made. This is the kind of the captivating effect of religion on any community. Whichever is the community, it is very difficult to escape the Kabanda Bahu of religions. Then let us see what the other community, Jehovah Witness, the other community, 2 children, Bijo Emmanuel and another, were rusticated from a Kerala school because they did not sing the national anthem, saying that our religion does not permit praising anything which is man-made, and we have right to speech and expression, which necessarily includes right to be silent. They stood up when the national anthem was being sung. The 1986 Supreme Court you have seen, which discusses the aspects of right to speech and expression, right to the religion, which includes right to conscience also, and the apex court upheld it. In America, when the national flag was burnt, the American Supreme Court said it is right to expression. It did not do anything. In France, when a particular scripture was burnt, the courts and the governments took very stringent action, notwithstanding the repeal of blasphemy laws. The blasphemy laws were repealed, and still action was taken under the provisions of French code, Napoleon's code. Whatever be the reason, just I want to say that this community is fanatic, that community is fanatic, this other community is not fanatic. That is not the case. All people, all sections of society have some elements of fanaticism, although they are in varying degrees. They are in varying degrees. This being said, what is religion? What is dharma? From religion to dharma, the apex court has traveled right from the days of Shirur Mutt case. The apex court referred to American Supreme Court judgment, refers to Australian judgment, refers to Bertrand Russell, and holds dharma is a very elastic concept. It eludes any specific meanings. Dharma, the meaning of dharma depends upon the prefix Raja Dharma. When Rama was coronated, there is one mantra which says, I am the emperor of this world and I am not answerable to anyone. Then Vasishtha, Vamadeva, they hold the Dharma Danda in their hand and put a gentle pat on the head of Lord Rama, saying, Dharma Danda is above you. You are under Dharma Danda. This is the constitutional, ancient constitutional law of this country. Kallana's Rajatarangini gives 18 constitutional principles how the king should govern, what he can own, what he cannot own, when he can sleep, when he cannot sleep, where he can hunt, where he cannot, how he should treat the downtrodden people. Everything is spoken of by Kallana's Rajatarangini. This Kallana is a Kannadiga from Hangal. He went to Jammu Kashmir, studied Shaivism there, and scripted this book. how our ancestors were. See what Will Durant says about this country, what Arnold Toynbee says about this country, what our great historian R.C. Majumdar authoritatively says. He says in Vedic era, 2 books which Bharatiya Vidya Bhavan has published. Mr. Raghavan is here, the president. It's a great honor to see him here smiling. They have written how the real dharma was. In real dharma, I'll come to that meaning, there was no discrimination. Dharma was treated, and rightly by the Supreme Court. Of course, we can have some criticism, is another. Nothing is beyond criticism. Even God is under criticism nowadays. Dharma, the Apex Court says, from 1996 to 2016, is a way of life. The dharma in this country was the source of much of law. It was source of constitutional law. It was source of international law. We had international law textbooks. We are under impression the first book on international law, law of war and law of sea, De Jure Belli Ac Pacis, by Hugo Crotius is the first book. No, we had lot of domestic law on all walks of life, all aspects of life. They have seen 18 Akshohini soldiers, army, facing each other during the Mahabharata period. Duryodhana had estimated that war would endure for a period of 15 days. And Bhishma said, stop, maintain status quo, till I hold discussion with Krishna Dvaipayana, formulate the war principles, and come and tell you to start. Till then, you are not supposed to wage war. 2 armies, full of tension, full of vigor, were made to wait for 3 days continuously. And the provision was being consumed. The soldiers, when they are idle, they consume more. This is what Napoleon Bonaparte, his biographer Emile Ludwig says. That was happening. And Duryodhana was worried how to provide food for these people. This old guy has gone to some Krishna Dvaipayana. Always I doubted him because he would decide for Pandavas only. He has gone there. That is the reason. He wants to weaken our side. That is the reason. Krishna Dvaipayana advised our Bhishmacharya, Bhishma Pitamaha, what should be the war principles. War would begin on the sunrise and would come to an end for the day when the sun sets. The foot soldier shall fight with the foot soldier. Rathika, the charioteer, will fight with the charioteer only. The animals shall not be troubled. Broken horses shall be spared. Women, children, aged and diseased shall not be targeted. More importantly, the 2 armies comprising of many kingdoms, they should be told on what principles the war is being fought. Those who agree with these principles, they can be on the one side. Those who do not agree, they can come to the other side. There was lot of halubalu, exchange, this army, part of this army, traveling, coming to this side, that side part, coming to this side. It went on for 1 more day. Then the war was fought broadly on those principles. R.C. Majumdar writes, we lost some wars. Porus lost our Alexander when he had come in BC 323. We lost the war because we were under impression that our war principles will be adhered. Alexander came, started the war during the midnight. He burnt the grass, damaged the animals, and cut the throat of people who were sleeping, because we never knew in war and love everything is all right. That was never our tenet. That was never the principle of our dharma. What dharma ultimately is, dharma is very difficult to define. One of the judgments of Dharmadhikari, Justice Dharmadhikari, says like this: dharma eludes definition. Let us see how dharma is seen in our ancient books. Generally, which P.V. Kane, he wrote 2 volumes on history of Dharma Shastra. Now it is 7 volumes. History of Dharma Shastra comprises of commentaries of great rishis and the decisions of the courts on those commentaries. He quotes Manusmriti. When we say Manusmriti, we feel little hesitant. Oh, he is quoting Manusmriti. But how many principles, great principles, are contained in that scripture? Who knows? Unfortunately, bulk of the society does not have access, at least it claims that it does not have access to Sanskrit. Very difficult to believe, because Ramayana was scripted by Valmiki, who is now scheduled tribe on our list. He wrote that Ramayana in a poetic form in Anushtuk Chandas. Anushtuk Chandas is considered to be one of the finest Chandasu in Sanskrit literature, and he wrote it. Therefore, if somebody says we were not given access to Sanskrit, etc., kindly do not believe them, because many commentaries on Vedas and Upanishads are contributed by the so-called ACSTs. Krishnadvaipayana, son of Meenugarala Maga, he classified 4 Vedas, the Vedas into 4 parts: Rigveda, Yajurveda, Atharva Veda, Sama Veda. And out of the 10 Upanishads which Adi Shankara had enlisted as the most prominent of 108 Upanishads, like 10 amendments to US Constitution, which we say Bill of Rights, they are Bill of Upanishads. Most of them, the commentaries have been contributed by non-Brahmins. Very often we discuss these things across the lunch table with my friend Devdas. Of course, some material which I have used without his permission in this speech also. That is how it was. And Manu Smriti, Manu is not a Brahmin. Manu was not a Brahmin. And Devdas says, Manu is not a person at all. It's only a position with his studies. And my studies accord with that. It was that way. The Vedas were classified by non-Brahmins, not only non-Brahmins, very low-class, so-called low-class people, whom Bakshi called as Aristotle of Atishudras in his the human rights and the future of human rights. Upendra Bakshi cites like this. That is how our Dharma Shastra was. Manu says this one, this very, very interesting. I am very, very curt in expressing whatever comes to my mind, because I have very matured audience here. So therefore, even if I commit some mistake, they will simply forgive. That's my impression. Manu says in his code 1063, Ahimsa, Satyam, Asteyam, Shaucham, Indriya Nigraha, Etam Samasikam, Dharmam Chaturvarane, Abravit Manuhu. Non-violence, truthfulness, abstaining from embezzlement, cleanliness of mind and body, control over one's senses. These are the general governing principles for all Varnas. This is very important. These are applicable to people of all Varnas. And Varnas were not Jatis. This we have to remember. Vishwamitra, who coined our Gayatra mantra in Gayatra Chandas, was only a Kshatriya. There were many, many Brahmins who were sent for grazing the cattle on the hillside. They were never treated as Brahmins at all because they did not have Brahma Vidya. And from one Varna to another, one could jump. There is a famous judgment of Madras High Court rendered by two English judges. That case is called the famous Tanjavur Palace case. One of the lawyers who had argued the matter was none other than Sir Alladi Krishnaswamy Iyer. What the Madras High Court said? Madras High Court said Shivaji was a Shudra and Shudra could become a Kshatriya, and therefore he became Kshatriya on his own strength. Nabhisheko na samskaro simhasya kriyate vane vikramarjita satvasya swayameva mrugendrata. For lion, whether there will be coronation ceremony? No. On its own strength it declares to the forest that I am the king, I am the emperor, everybody should obey it. On his own strength. This is what Madras High Court said, ILR 1925. One of the beautiful judgments, the celebrated judgments of Madras High Court. Many other courts might have followed, at least 3 high courts have followed that. A Shudra could become a king, and king could marry the lady on Khadga Samskara, and the children begotten of that lady are the worthy successors of the king. That is how the share in that Tanjavur palace was accorded to the children of the great grandchildren of Shivaji when he went there that side. That is how it was. That is how it was. What Manu has said, Yajnavalkya in his Yajnavalkya Smriti, I assume that little Sanskrit will be known to you because many of Sanskrit words are in Kannada. Kannada has borrowed, like Tamil, a huge amount of Sanskrit to become a beautiful language. Like Tamil, we say Tamil people are generally it is said like that, which is not true. Puje. Puja is a Sanskrit word, but it's a combination of Sanskrit and Tamil. In Tamil, Poo means who, flower. And when you do puja with flowers, that becomes puja. And there is a great literature on this. Great literature on this. In the case which Indian government fought for bringing Lord Nataraja back to India, what English judge has said about our culture, our civilization. Why our dharma is great? I said what Manu has said now. Manu's version is approved by Yajnavalkya. Yajnavalkya is considered to be the great lawgiver. Yajnavalkya Smriti is full of law, full of dharma, and how to interpret law. Your Crawford, your Sutherland, your Rondzen, they are just nothing. They are just nothing. Just believe my words. After a lot of study, I am making this humble assertion before you. How to interpret law is a great subject where the Sanskrit texts teach how the text of dharma should be interpreted. We had non-believers like Charvaka. Charvaka said, this body will fall down, life will come to an end, therefore borrow money, buy ghee, eat ghee, enjoy life. When you are dead, your body is burnt, let it take some time. There is such a shloka. He never believed. He said, Paramanushcha Paramanubhyo Namaha. Perhaps Einstein was inspired by that. In one discussion with Bose, S.N. Bose, Einstein mentioned the greatness of Sanskrit and Sanskrit literature. Yajnavalkya, he also endorses what Manu has said. Then on Yajnavalkya Smriti, you have commentary of Vijnaneshwara. This Vijnaneshwara, a great scholar from Gulbarga. We have Vijnaneshwara Trust, where I happen to be one of the trustees. since days of Justice Rama Joyce. He wrote a commentary on Yajnavalkya Smriti, and that became which one? Mitakshara, limited letters. Mita, Akshara, Savarna Dirgha Sandhi, A, Mitakshara. That is the greatness of this country. But we are swayed away by all cheap writings. We look into WhatsApp messages, we form opinion, and on that opinion elections take place, the governments are formed, policies are formulated. How country will prosper? And we are prospering. We are still prospering. I'll just see within few minutes I'm completing. It's a very, very huge topic. You have to give me 5 to 6 hours to speak on this. But time is, I have to see at least clock, if not the calendar. Yes. This dharma from the Vedic literature is Dhammapada of the Buddha the Great. What dharma injuncts with little modification as are required for the local conditions, Buddha the Great taught the people. He instructed the people. Therefore, I only say, and there are Jaimini's writings, there are Tirthankaras who have written a lot about ahimsa, all these things. And one last thing which there is one more, Shabara Swami writes, dharma through which human beings would claim the pleasure, peace, progress and delight, and that would be his oath for the commentary Jignasva. To the common citizenry, the Smriti teaches dharma, achara, that is personal conduct, vyavahara, that is interpersonal conduct, prayaschitta, that is penal code. The jurisprudence dharma in the matters of state and diplomacy is taught in Mahabharata, Bhishma to his grandnephew Yudhishthira. 2 things, 3 things I should say before I conclude my speech. Duryodhana went to Mother Gandhari to take her blessings before he commenced a war. Mother Gandhari, bless me with victory in this war. Gandhari said, Yato dharmascha tato jayaha. Where things are done in accordance with the tenets of dharma, there the victory will come. The delinquent son went disappointed. Mother is conspiring against me, was his comment. And you know the result of war. That has become the emblem of our Supreme Court. Yato dharmas tato jayaha, which Justice Rama Joyce in his famous book, The Legal and Constitutional History of India, very beautifully he has written. This is published by the Indian Law Institute, one of the best books. It needs to be updated is another thing. Then in Shikshavalli of Taittareya Upanishad, the Guru, after having taught the Vedas to his children, the disciples of all communities, this is very important. Gurukulas were meant for people of all communities, including the children of women of easy virtue. I will not say more than that. Women of easy virtue. Their children are entitled to gain entry to Gurukula. One is Jabali. When Jabali went to seek admission, the Guru asked, who is your mother, father? He went back to mother and asked, who is my father? She said, I am a woman of easy virtue. I do not know who your father is. He came and narrated the same thing to the admission authority in the Gurukula. He was admitted as the student. He becomes the great Rishi, Jabali, Jabalpur in Madhya Pradesh is named after that Rishi. Then in Shikshavali, in Taittiriya Upanishad, the Guru, after having taught the Vedas to the children, He says, Satyam vada dharmam chara. Speak truth, follow the path of dharma. Then we have emblem for the high courts in the country. What is that emblem? Satyameva jayate. Taittiriya Aranyaka. Satyameva jayate. Satyam eva jayate. Only truth trims. Non-rutam. Sullalla. Not the falsehood. Then coupled with that, Satyam bruyat, Priyam bruyat, Nabruyat, Satyam apriyam. When you speak truth, it should be benevolent to the community. A truth that will cause a fire, skirmish, friction. You are not supposed to tell that truth. There is one judgment of Justice Krishna here when he was the judge of the Kerala High Court, where truth was cited as the defense for contempt of the court. And the lawyer argued, Satyameva Jayate is a constitutional motto. And that is your emblem here in the High Court. We only said the truth. Justice Krishna here said, even in pursuing truth, there should be sense of proportion. Perhaps he got that, drew that wisdom from this particular shloka, which says, Satyam apriyam, nothing, nabriyat satyam apriyam. Same time, you are not supposed to lie merely because it is going to generate lot of happiness in all the people in the audience. No, you are not supposed to say anything which is false merely to make the people happy. Satyam bruyat, priyam bruyat. Nabruyat, satyam apriyam. How many? I can go on enlisting, but the clock is warning me that I have to stop here. Stopping is... Thank you, sir. So, this I can only say what Cardozo had said. The inn that shelters the traveler is not the journey's end. With this, I complete my speech. Thank you. Thank you so much. I should say one word. Our Tarak Ram was a great member of the bar. I had an opportunity to brief him in quite a few matters. He's a personality, very short person, not that impressive. One of my friends took me to him. I said, I am not ready to brief. Then he insisted, you see first. I briefed him. That was a matter relating to whether there can be doctrine of common hodgepodge in a joint Hindu family which does not own any property at all. Because English judges treated doctrine of common hodgepodge as something mixing with the property of the joint family. Then Mr. Tarak Ram argued that matter and procured a judgment in our favor, which was a turning point in my professional life. I pray that Madam is also here. I salute you, and he had the gift which he has inherited from his great father, who was a lawyer having great advocacy skills, and that gift he bequeathed to his son Tarak Ram when he breathed his last. Thank you so much.
Thank you, Justice Dixit, for your scholarly lecture.